Hello everyone, welcome back. In this video, I'm going to talk to you about the two types of Baker Act. Yes, there are two types of Baker Act here in Florida. The one you're probably most familiar with is the Involuntary Baker Act, the one that kicks off that 72 hours. And I talked in another video about when the 72 hours might actually begin, when it doesn't begin, what, the tolling of all that time. But basically, the 72 hours is associated with an involuntary Baker Act, which is initiated either by law enforcement, a court order, or a qualified professional such as an emergency room doctor or even a licensed clinical social worker. That's the involuntary detention. But there's also the voluntary detention. In other words, where you actually agree to it. Well, how can that be? Why would anybody actually agree to be Baker Acted? And the statute says that in order to agree to it, in other words, in order to voluntarily consent to be Baker Acted, you must give informed consent, right? You have to have been told what the consequences are of doing so. One of which is if you are on a voluntary admission basis, that there is no clock ticking. There's no 72 hours. In fact, you could be held in theory indefinitely without a court order. No judge, no hearing, no lawyer, none of that stuff. Well, sometimes what happens is, and this happened a lot during COVID, when people couldn't get in to see their doctors or their clinicians or whatever it happened to be, and they were showing up in emergency rooms, calling 211, calling 911 for help of some form or other. And then what would happen is they'd show up at an ER, for instance, and the hospital and the staff there would say, "Oh, are you here for an assessment? Or are you here because your meds aren't working and you'd like to have us see if other meds would be more appropriate?" And they say, "Yeah, yes, that's what I need. I need to be assessed. I need to have my meds reviewed." Great, sign here. And what you just signed was a voluntary admission agreement agreeing to be Baker Acted, agreeing to become a ward of the state of Florida. Did they tell you what that meant? Of course they probably didn't. Okay, not really informed consent. Here's the other way that you can become voluntary. Let's say that you are involuntarily detained, the one associated with the 72-hour clock. At the end of that 72-hour period, in theory, and again, this is all theory, we're presuming that the facility is actually going to follow the law, which a lot of the time doesn't actually happen, and I'll talk to you in another video about why that doesn't happen. But in theory, after 72 hours, one of three things is supposed to happen. Number one, they let you go. Number two, they file a petition for placement. In other words, they file a petition to actually try and keep you potentially up to 6 months. Or they get you to sign a voluntary admission agreement. Again, all based on informed consent, understanding and knowing the consequences of what might happen if you do sign the voluntary admission agreement. But unlike the involuntary, there's no clock ticking. It's an indefinite hold. And so two types of Baker Act, voluntary, involuntary, and understanding what you're dealing with is very, very important, because depending on whether you are voluntary or involuntary, we might, if we're going to file a case for you, we might argue different things to the court. We might ask for different relief, right? There may be different legal objections that can be raised. So knowing what's going on here is very important. So I wanted to share that with you. Two types of Baker Act, voluntary, involuntary. And here's the other rub. You could go from involuntary to voluntary, right? But you can't go from voluntary to involuntary. It's only a one-way street here. Although the state is still free to extend your detention, to petition the court for extended detention up to 6 months, whether you are voluntary or involuntary. And if that doesn't confuse you, I'll do the best I can in the next video to make sure I do confuse you, which is why I am a big fan of not trying to handle these cases yourself, because the Baker Act is a convoluted, complicated mess. And as many times as I've read it, I learn something all the time, every time I read it. And oh, by the way, they just made a bunch of changes in 2024, as if it wasn't confusing enough already for you. Anyway, I hope that helps. If you liked the video, please give me a thumbs up and please subscribe to our channel. Thanks for tuning in. See you in the next video. Bye-bye.